A company collapses and enters liquidation. Creditors are owed hundreds of crores. Employees have lost jobs. Investors are facing substantial losses. The liquidator begins reviewing company records and discovers a disturbing pattern. Corporate funds were diverted. Related party transactions enriched insiders. Assets disappeared without proper explanation. Company property was used for personal benefit. Governance controls failed. The question now becomes critical. Can the individuals responsible simply walk away? Can directors hide behind the corporate structure after causing losses to the company? Or can the tribunal compel them to repay money, restore property, and compensate stakeholders? The answer lies in one of the most powerful accountability provisions under the Companies Act 2013, Section 340, dealing with the tribunal's power to assess damages against delinquent directors, officers, managers, liquidators, and other responsible persons. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today, we are discussing Section 340 of the Companies Act 2013, a highly significant provision within the winding up framework that focuses on accountability, recovery, and restoration of corporate value. This provision is extremely important because liquidation is not merely about distributing existing assets. It is also about recovering assets that should have remained with the company. It is about identifying misconduct. It is about restoring losses. It is about ensuring that individuals entrusted with corporate power remain accountable for how they exercise that power. Section 340 serves precisely this purpose. To understand the significance of this provision, we must first appreciate a fundamental principle of corporate governance. Directors, managers, officers, and liquidators occupy positions of trust. They control resources belonging to the company. They make decisions affecting stakeholders. They exercise powers granted by law. With those powers come responsibilities. The legislature recognized that where those responsibilities are abused, remedies must exist. Section 340 provides such a remedy. The legislative intent behind the provision is straightforward. Stakeholders should not suffer losses arising from misconduct without the possibility of recovery. If company property has been misapplied, it should be restored. If losses have been caused through breach of duty, compensation may be appropriate. If fiduciary obligations have been violated, accountability should follow. The section, therefore, strengthens confidence in the corporate legal system. One of the most important concepts associated with Section 340 is misfeasance. The term misfeasance is frequently encountered in company law and professional examinations. Misfeasance generally refers to improper exercise of authority or improper performance of duties resulting in loss or damage. This concept is extremely important. A person may possess lawful authority. However, if that authority is exercised improperly, liability may arise. Corporate power is not unlimited. It must be exercised responsibly. This distinction creates one of the most important examination concepts. Not every business loss results in liability. Not every unsuccessful decision constitutes misconduct. The law recognizes commercial risk. Directors are not guarantors of business success. Markets fluctuate. Economic conditions change. Competition increases. Business judgments sometimes fail. Section 340 is not intended to punish honest commercial mistakes. The focus is misconduct, breach of duty, misapplication of assets, and improper conduct causing loss. This distinction must always be remembered. Another important concept under the provision is breach of trust. Corporate officers hold company assets in a position of trust. They are expected to act honestly. They are expected to avoid conflicts of interest. They are expected to use corporate resources for corporate purposes. Where these obligations are violated, legal consequences may follow. Section 340 reinforces this fiduciary principle. The provision also addresses situations involving misapplication of company money or property. Corporate assets belong to the company. They do not belong to individual directors. They do not belong to promoters. They do not belong to managers. Any improper use of those assets may attract scrutiny. A practical example can help illustrate the significance of the provision. Suppose a director causes the company to purchase assets from a related entity at significantly inflated prices. The transaction benefits insiders while causing loss to the company. Years later, the company enters liquidation. The liquidator investigates the transaction. Section 340 may provide a mechanism for seeking compensation and recovery. Consider another example. A manager authorizes payments lacking proper approval or commercial justification. The company receives no corresponding benefit. The payments contribute to financial losses. The company subsequently enters winding up. Questions regarding accountability may arise under Section 340. These examples demonstrate why recovery provisions are necessary. The governance philosophy behind the section is particularly powerful. The law does not merely seek to identify misconduct. The law seeks to repair damage caused by misconduct. This distinction is important. Recovery is often more valuable than punishment. Stakeholders benefit when assets are restored. Creditors benefit when losses are recovered. Employees benefit when the asset pool increases. Investors benefit when accountability mechanisms function effectively. Another important feature of the provision is the role of the tribunal. The tribunal acts as the adjudicating authority. It examines records. It reviews evidence. It evaluates transactions. It hears explanations. It determines whether misconduct occurred. If liability is established, appropriate orders may be passed. These orders may require repayment of money. They may require restoration of property. They may require contribution toward losses. They may require compensation. The tribunal therefore possesses significant powers to protect stakeholder interests. For directors, Section 340 serves as a reminder that corporate decisions may be examined long after they are made. Good governance is therefore essential. Transactions should have commercial justification. Approvals should be documented. Conflicts should be disclosed. Professional advice should be obtained where appropriate. Strong governance reduces future risk. For company secretaries, the provision highlights the importance of documentation. Board minutes, committee minutes, related party approvals, disclosure records, regulatory filings, all may become important evidence during investigations. Good secretarial practices provide protection for both the company and its management. For chartered accountants, financial records frequently form the foundation of recovery proceedings. Accounting entries, bank statements, audit observations, supporting documents, reconciliation reports. These materials often determine whether liability can be established. For cost accountants, operational records may reveal whether transactions had genuine commercial justification. For advocates, proceedings under Section 340 often involve detailed factual and legal analysis. Questions of duty, questions of authority, questions of disclosure, Questions of causation, questions of loss, all become relevant. One hidden examination concept involves causation. The existence of misconduct alone may not always be sufficient. There must often be a connection between the conduct and the loss suffered by the company. Understanding this relationship is important for both examinations and professional practice. A practical case study illustration can further explain the section. Imagine a company entering liquidation with liabilities exceeding assets by 400 crore rupees. Investigations reveal that substantial corporate resources were transferred to connected entities over several years. Commercial justification appears weak. Documentation is inadequate. Stakeholders seek recovery. Section 340 provides a framework through which the tribunal may assess conduct and determine whether repayment or compensation should be ordered. The provision, therefore, serves as both a governance safeguard and a recovery mechanism. Another important governance lesson is that transparency remains the strongest defense. Where decisions are documented properly, supported by professional advice, approved through appropriate processes, and undertaken for legitimate business purposes, governance risks are significantly reduced. Poor documentation frequently creates unnecessary exposure. The section also strengthens investor confidence. Investors are more willing to commit capital when they know that legal mechanisms exist to recover losses caused by misconduct. Accountability enhances trust. Trust supports capital formation. Capital formation supports economic growth. Another hidden practical insight is that many governance failures become visible only during liquidation. Transactions that attracted little attention during normal operations may receive intense scrutiny during winding up. This is why governance should never be treated as a box-ticking exercise. The provision also connects closely with sections 339, 341, and other provisions dealing with fraudulent conduct, misfeasance, recovery of property, fiduciary duties, and stakeholder protection. Together, these provisions create a comprehensive accountability framework. From a secretarial audit perspective, unexplained transactions, weak internal controls, repeated compliance failures, undocumented approvals, and conflict of interest concerns should always receive careful attention. Such issues frequently become critical during liquidation proceedings. Although Section 340 does not prescribe ordinary resolutions, special resolutions, explanatory statements, or routine ROC filing obligations, its practical impact can be substantial. Crores of rupees may be involved. Personal liability may arise. Assets may be restored. Stakeholder recoveries may increase. The consequences can therefore be significant. For company secretaries, the provision reinforces governance discipline. For chartered accountants, it emphasizes financial integrity. For cost accountants, it highlights operational accountability. For advocates, it provides an important recovery mechanism. For directors and officers, it serves as a reminder that corporate authority must always be exercised responsibly. As we approach the conclusion, it becomes clear that Section 340 is fundamentally about accountability and restoration. The law recognizes that businesses may fail despite honest efforts. What it does not permit is misuse of corporate power without consequences. When misconduct causes loss, the law provides mechanisms to recover value and protect stakeholders. In conclusion, Section 340 of the Companies Act 2013 represents one of the strongest recovery and accountability provisions within the winding up framework. By empowering the tribunal to assess damages, order repayment, restore property, and require contributions from delinquent directors, managers, officers, liquidators, and other responsible persons. The section protects creditors, investors, employees, and the integrity of the corporate legal system. For company secretaries, chartered accountants, cost accountants, advocates, insolvency professionals, directors, investors, and governance practitioners, understanding Section 340 is essential because it reinforces a core principle of corporate governance. Those entrusted with corporate power must remain accountable for how that power is exercised. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SAY-BEE, Prohibition of Insider Trading Regulations, 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.